Thank you all for joining us tonight and making time for this. In my practice, I realize more and more each year how much people don't know about what to do after a loved one dies. And there's a lot of panic around it. Am I doing the right thing? Should I be doing this? Should I be doing that? And people, either through culture or hearing friends' stories, they get so panicked about it that often I get phone calls from folks saying, my loved one just died and I need to know what to do. And I'm assuming they meant this week. And with some gentle conversation, I realized the body's not even cold yet. So if there's one takeaway from this entire presentation that I want you to remember is there is always time to breathe, and processing your grief initially to the extent that you can is really, really important. With rare exception, everything can wait. It can wait. You don't have to start doing stuff from the hospital room or your loved one's room or wherever you happen to be. It can wait. So, in order of things that you want to start thinking about after your loved one dies is, what were their last wishes? Did they want to be buried? Did they want to be cremated? Did they leave you instructions? If so, that's a kindness. But often people have so much trouble talking about death that they don't leave instructions behind. So in that case, are there family members that you can talk to and make the best guess? The other thing that can be kind of important is if your loved one hasn't done any estate planning and hasn't made sure that their accounts are titled in a way that will allow them to stay open after they've died, you might need to do some very quick work to try to preserve some of that availability. So if I had an account only in my name and didn't have payable on death or transfer on death designations on it, then it was shut down. They shut them down very, very quickly. So one of the sort of administrative tasks that is really helpful to do before your loved one passes is to make sure that the beneficiary designations are up to date and as your loved one wanted them, and to make sure that at least one checking account with some money in it has a payable on death designee if it's not jointly held, because then you can continue to access that money to pay for the final debts. Now, that doesn't always happen. So it's okay to go ahead and pay for expenses, but just keep really good receipts because you're entitled to be paid back if they have any assets. All right. And I'll pause for just a minute to see if there are any questions at this stage. Are there? Okay. All right. So the other big takeaway is, depending on where you live, probate is not something to be afraid of. I think a lot of folks have sold the notion that probate is this big, bad, awful, scary thing. It's not typically. There are some jurisdictions in which it is unpleasant and very, very time consuming, but those tend to be the minority. Typically, the people in the probate clerk's office are the nicest folks in the court system, and they bend over backwards to help you. The only thing about the probate process that tends to be unpleasant is whomever is stuck dealing with it is usually somebody who's in active grief. And they're having to go through all these ticky-tacky details on the court schedule. So that tends to be the bad thing about it. And for those of you who don't know, probate just means the court supervised distribution of your assets. So whether you have a will or you don't have a will, which is called dying intestate, the court has to supervise the distribution of your assets. If you have a will, the court will follow your set of instructions. If you don't have a will, every state has a plan, an off-the-rack plan waiting for you. It might not be what your loved one would have chosen, but that is the default that the state will turn to. Okay. So there will be a plan in place. Now, some states have what's known as small estate administration. My favorite, Roseanne, was Pennsylvania. Their small administration is referred to as the orphans court.
Yes, it is.
Each state does it a little bit differently. So, for example, in the Commonwealth of Kentucky, you can take advantage of the small estate administration process if you are the surviving spouse or you are a surviving child whose other children are willing to agree to shorten the process, and if the total value of the estate is less than $30,000. Other states, you can go as high as 75,000, and you don't have to be that close of a family member. Personally, I wish all of the states would just sort of set a threshold, and if it's below this amount, we can do it quickly and easily. But each state sets its own rules. So it would be important to familiarize yourself with your state's rules or contact a local probate attorney and have them help you with that. In the materials that are available tonight, there is a link. It's a 50-state survey of the small estate administration procedures and qualifications. So you can take a quick look at that and see what's in place for your state if you have any concerns. All right, then once you've had a chance to breathe, then there are some things that you want to think about getting done relatively quickly. At the funeral home, they will typically request copies of the death certificate for you. I recommend between 5 and 10. You used to absolutely have to have the 10 because different places insisted on seeing the original. Since COVID, financial institutions and other institutions have become much more reasonable about accepting scanned versions. So at least 5, but you might consider between 5 and 10. The funeral home will typically let the Social Security Administration know about the death. So if your loved one is receiving Social Security and you have access to their account, either because your name has been added to it or after you're appointed the person in charge of distributing the assets, don't distribute that money for a month or two because they prorate payments. So say you get your payment for an entire month on the 5th of the month, but you pass away on the 6th. Social Security will claw some of that back. And a lot of families are sort of left wondering why there was money in the account and then it went away. The same with military retirement and things like that.
Larisa, let me jump in for 1 second.
Mm-hmm.
Louise, did that answer your question? Okay. All right, go ahead.
Okay. Sorry, I'm bad about looking at the chat, y'all.
No. I have you. You
Okay.
guys keep going.
Then depending on your family situation, you might need to take a few more immediate steps. If your loved one was still living in their house, I recommend that you make sure the house is secure. If there are any pets in the house, make arrangements for somebody to deal with those. Minimize the burden of the utilities and the water by turning them down as much as you can. But the big thing is, don't let family members in going through willy-nilly picking out the stuff that they want, right? In all of my probate cases, people don't fight about money. They fight about stupid stuff, really stupid stuff. So if you're the one named, as some states call it, a personal representative, other states call it an executor. But for the female version, some states insist on executrix. I don't ever use it. It sounds too S&M bondage for me, but those are the names that you'll be hearing about, okay? If that's you, then as kindly as you can during a time of grief for the family, just tell everybody to cool their jets. And you can say, nobody can really be dealing with this stuff until The court appoints somebody administrator of the estate if there's no will, or executor or personal representative if there is one, and we'll get to it in time. Any more questions before I go through like a runaway horse with all of this? Okay.
I
All
think
right.
you're good.
Okay. Then the next thing, if anybody has a loved one who's in the military, there's sort of some tips that I want to share with you. If they're receiving retirement income, then they've been logging on through a site called DFAS. That is where they get information about their retirement benefits, their disability benefits, things of that nature. You do need to let them know quickly, and they're trying to shove everything through the website now. But like the banks, DFAS will shut down their accounts almost immediately. So if you know your loved one is sick and they are a military veteran, work with them and make sure that you can get any information off DFAS that you might need later as part of their retirement information. Because the minute you call to let them know, access to that website is shut off. And there really is a lot of information in there that you will need. And the 1-800 number, it's really hard to get through. In my materials, I've also got a link to sort of a helpful pamphlet that the VA puts out about post-death benefits available to veterans and their families that a lot of folks just don't know about. So it's important to take a look and go through that. The next things that people fret about often is, what do I do with my loved one's debts, right? They had these bills outstanding. What do I do about that? So don't feel like you have to pay those immediately. I only practice in Kentucky, so I can't give specific legal advice about specific jurisdictions, but it is common in all states that once the probate, which is the court supervised distribution of assets process, has begun, then any creditors have to present their claims in a certain way to the court, and they have to do it properly. But a lot of family members think that they are personally responsible for their loved one's death. That I do not believe is the case in all 50 states. I'm not sure about all of them, but you're not responsible personally for your loved one's death. And if they have any assets left in their estate, and they have significant debt, you really do want to talk to your local probate attorney about what the local rules are for presentation of those claims and which you can legitimately refuse to pay. And I did just see 2 questions. One is, how long after a loved one passes away does the executor have to distribute the assets? That varies from state to state too. It's typically enough time to allow you to catch your breath and breathe. So usually what happens is you file the document that opens the probate, and then the court will have an initial hearing to appoint an executor if there is a will, or an administrator if there's not. Then once that person is appointed and the court issues the official orders that gives them the power to talk to the financial institutions directly and find out what assets the loved one had, then they have a period of time to get an initial sense of what all those assets are. And they have to file in Kentucky something called an initial inventory. And then you have a period of time to confirm that you found everything. And if your state permits an informal resolution, then after a sufficient period of time set by your state's law to give creditors ample time to present their claims and be responded to, then you can start distributing the assets. But again, rules of court and local practice vary from county to county and from state to state. So you do want to check with someone local if you are going to open up a probate for anything significant.
Larisa, is there a way to
yeah.
avoid probate?
There is. Anything that can pass by beneficiary designation, like a life insurance policy or retirement accounts, or by what's known as payable on death or transfer on death policies, those are outside of probate. Real estate, unless it's jointly owned, is typically the asset that triggers probate if it hasn't been put in a trust. And a trust is just a legal creation that you can put your assets in. Roseanne's heard this before, but all estate planning is, it sounds fancy and it sounds complex, but all it is about a couple of simple concepts. You pick trusted helpers, people you trust to help when you need them to help, and you give them the legal authority to help and a set of instructions to follow. So a will is your set of instructions after you've died, but a trust can contain a set of instructions for the property in the trust while you're alive and then after your death. Courts only supervise wills and the lack of a will. If you have a set of instructions and assets in a trust, if nobody's challenging that, then the court's not involved, and your trustee, so that's the name of your trusted helper for a trust, your trustee will just look to the set of instructions in the trust and can distribute those assets on their own schedule. And then somebody asked about filial laws in some states that can claim medical expenses from the children. So I'm not sure about other states. Kentucky does have a filial law on the books, but to my knowledge, it has not been enforced in many, 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 many years. So if you're hearing from people that you know that your state does have those laws, then you might want to consult somebody local. I would be shocked if that's just sort of universally the case without exception. All right. You don't have to go with probate if everything was jointly held. So, for example, in my own family situation, when my father died, all of his checking, savings, all of his financial accounts were jointly owned with my mother. We had put their real property in a trust, but even if we hadn't, it was all jointly owned with my mother, and she was the beneficiary of his retirement accounts. So he had no probate estate. Everything that he owned just passed to his joint account owner or by beneficiary designation. So we didn't have to open a probate for my father. Now, for my mother, we hope not to have to fool with that either, because we're staying on top of her expenses so she won't have any creditor claims. We have transferred what assets we can to a trust. And my sister and I are joint account holders for some of her smaller accounts, just so that they won't close down when she passes away. It's not a good idea to go willy-nilly putting children or other family members other than spouses' names on all financial accounts. And the reason is this: if somebody is a joint owner, then those assets are available to their creditors. And every parent thinks that their children are precious, delicious angels straight from heaven, but not all children are. Some drive too fast, some get in accidents, some drink, and some get divorced. So one or two small accounts that could pay for the burial and the probate attorney, that's fine. But everything else, there are better ways to handle dealing with that.
You have it.
So the trust drafted in one state and the loved one no longer has capacity and they've moved, is it on? Yes, the full faith and credit clause of the United States Constitution allows that. That being said, it might be more advantageous to change the situs and the governing law of the trust to the new state. So you'd want to consult with a local estate planning attorney to see if that's the case. Most trusts permit that. If you move and you need to change the laws that govern the trust, or trust situs means where the trust itself is located. And state law can determine that based on where the trustee is located, where the assets are located. That's another one where you want to get responsible local help to just advise you on what would be in your family's best interests. Typically, well-drafted trusts have some provision for modifying the trust if the original trust makers have now lost capacity. Either somebody is allowed to modify the trust by explicit grant of authority, or by power of attorney, if that permits trust modifications, or there's language now in a lot of trusts that give somebody called a trust protector the ability to modify the trust as needed for the trust maker's benefit due to a change in the law, due to a change in circumstances. And then the next one, there's a difference between an account signer and an account co-owner. Yes. So you can, through a power of attorney, you could have authority to sign for your loved one, but you are not the owner of that account unless your name is on the account as a co-owner. So even though you can write checks on behalf of your loved one through your power of attorney powers, when that loved one dies, if they are the only owner of the account, your ability to access those funds dies too. All right, Roseanne, did I miss any?
You did not miss a thing. Nope.
All right. The next thing that's sort of important to do after you've had a chance to get through the initial shock and the initial numbness is, because of the rise of identity theft, you want to let the credit reporting agencies know that your loved one has died. All you have to do is let one know, and then they'll let the others know. If you forget to do it, it's not a crisis, but it can be helpful, because a common use of identity, they just find out who's died and then they start using them. During COVID, my late father applied for unemployment insurance. And, we had done everything we need to do, and they still managed to get through. So
wow,
that's one thing to think about. And then the list that is in the materials, it's a checklist for things to do immediately, within a week, within the first month, after a bit. It is particularly helpful, not to be sexist, but for the men in your family or firstborn type A loved ones who just need a task. Give them the list and have them start checking it off. Because as we all know, grief manifests in some very strange ways. And there's always one or two people in the family that need things to do, because if they have to stop and think about things, it's too overwhelming. And if it's too overwhelming, they either curl up in the fetal position figuratively, or their grief comes through as anger. So the checklist is good for those people. You just say, here's the list. Start checking these off. Do what you can do. Because there's lots of the stuff on there that somebody who's not necessarily the executor or the person in charge can still help with. And I've dumped just a huge amount of information on you all. So I'm going to stop talking for a minute and give you all a chance to ask some more questions. Remember that even though I'm a lawyer, I can't give you specific legal advice. I can just talk in generalities. So if you have a highly specific question about an ongoing probate in your state or for your, I'm not allowed to answer that, but I'm happy to answer any questions about the process generally.
Okay, let's see here.
Oh,
Yeah.
about people stealing from the house during the funeral. It depends on where you live, right? The first thing that I recommend, if you're in an area where that's a concern, is you get the locks changed on the doors. Do that first. That's an important task. And that's a good task to hand off to somebody who needs a job, is to do that.
That was big for a while, wasn't it? Where people would look in the obituaries and see where people lived, and then they would ransack the house. Awful.
Yes, a friend can help with the checklist. There's plenty of stuff on there that a friend can help with. I can tell you from personal experience, you'll get a lot of, just let me know if there's anything I can do. Well, it's hard to ask for help. You know, don't be afraid to say, I could use a meal, or can you do this? If you're in that situation where somebody else has just lost a loved one, remember how hard it is to ask for help. Drop off groceries, mow their lawn without them asking. When we're grieving, it's the minutia of life that just becomes one bridge too far often. You know, figuring out what meal to put on the table. That's why people bring food to funerals. It's having to figure out how to get a meal on the table just seems overwhelming. So whatever little bitty things you can do unbidden and without chatting can be a help.
Yeah.
And then the next question I saw is, why do people fear probate? In some jurisdictions, it can be very costly, can cost a lot of money, and it can be very time consuming. I hear horror stories about California and Florida in particular. So in those states, you probably want to do what you can to avoid having to go through the probate process. But as I said earlier, in most states, it's not probate that's inherently awful. It's that somebody you love has died, and now you're on a schedule, and you have to go through these ticky-tacky little details and get all this stuff done when the court tells you you need to get it done. For some families, however, if there's no will, if it's a blended family situation, then probate can expose a whole bunch of ugliness. So if you know that that's your family situation, best to consult with an estate planning attorney, ideally one who specializes in blended families, and will help you walk through the things you need to think about to make sure everybody's still speaking to each other the first Thanksgiving after the loved one dies. How do you handle siblings who won't help with any tasks but want all of their questions answered as if they are doing something? Well, that's so common with elder care generally, and it's also common in probate. So there's always one sibling, usually the daughter, right? You can have a family of 12 kids, and if only one of them's a girl, everything's getting dumped in her lap. But regardless of the gender mix, there's always one sibling who tends to do just about everything. And then I say one sibling has the laboring oar, and the rest just want to loudly voice opinions about the direction of the boat and how fast it's being rowed, right? It's the same with the after death process. It really, really is, unfortunately. So if you're the person stuck doing it, you can choose to answer or not, depending on which is most likely to preserve family harmony. One thing that a lot of folks are surprised about is when siblings who are not the executor or the administrator or family members call the attorney typically will not speak to them. Not because they're rude, not because they don't care, but the attorney's relationship is with the executor or the administrator of the estate. That's the attorney-client relationship. They don't have permission to talk to other members of the family. Legal ethics rules will not allow us to do that unless you, the person who's been appointed, gives that permission. Now, think carefully if that's you, right? If you've got a loved one in the family who has to talk through everything, and has a lot of questions. In estate planning, it's typically flat fee billing, although some bill by the hour. But in probate, because we can't predict how long a probate will take, we bill for our time. So if I'm spending an hour on the phone with a sibling with lots and lots and lots of questions, I have to bill for my time. You know, a quick phone call here and there, most of us don't bill for. But we all have the nervous Nellies in the family who need a lot of hand holding and a lot of reassurance. So if you're going to give your attorney permission to talk to anybody other than you, just know that that increases the cost of the help with the probate. Then generally back to the handle siblings who won't help with tasks but have lots of opinions. For your own estate plans, if you're doing will-based estate plans, not trusts, but just wills, no co-executors. Courts hate that. Hate it, hate it, hate it. Financial institutions hate it. It needs to be chain of command. And if you're fretting about hurting somebody's feelings, nobody in the history of probate has ever said to an executor, "Thank you. You did such a wonderful job. We just admire everything you did for the family, and we are so appreciative of the time it took for you to do all of that. You did a fabulous job, and we love you," right? Somebody's got to complain. So if you're fretting, particularly with children, I say this only half the way tongue in cheek, you pick the child that gave you the most trouble as a teenager, because this is how you get payback, right? And if the one who's number 3 gets their feelings hurt, you say, nope, don't tell the others, but that's proof we love you best. And then you go about your business. All right. So that's will-based plans with executors. I can't speak to differences or issues in common property states because I have never practiced in one, unfortunately. Kentucky is a separate property state, but with an opt-in common property system if you are creating a trust. So I apologize, but I don't have the information to share with you about that. To clean out the safe deposit box, you either have to be an authorized user, or you have to show the bank the death certificate and the court order appointing you executor or personal representative, those terms are interchangeable, or administrator. And that underscores why we don't ever, ever, ever store wills in safe deposit boxes. Safe deposit boxes are great for your coin collection, for stock certificates, for savings bonds, for jewelry. They are not a good place for estate planning documents, because if you're not a co-owner, to get into the box, you have to have the court order appointing you executor or administrator. To get that court order, typically the court requires an original will. So if you've got the will in the safe deposit box, it becomes this sort of this circular jumble. Nobody breaks into homes outside of really crazy blended family situations and steals estate planning documents. So a home safe and your loved ones are told the combination, or a fireproof box, those are better places for your estate planning documents.
Larisa, I love that.
A lot of people, I mean, it used to be people just put all their legal documents in there, right? That shouldn't be.
No,
So
no, because you really can't get to them.
no.
Wow. That's fantastic.
Any other questions?
I have a story from a financial planner, and he said to his client, just make sure that you know where all the important documents are. And the client said, yes, my mom said all the important papers are here, all my important papers, but they never looked. The important papers were the newspapers they had saved from like the 1940s. it wasn't the documents, because they never checked before they passed away and they couldn't find them.
Yeah, there are, if for your own personal stuff, or if you have a loved one that's aging and is willing to do it with you, we do estate planning binders that has, it's designed to be sort of something readily identifiable that the family can go to, and it will have the estate planning documents, but then other room for beneficiary designations, other helpful documents. You think there's little things that we forget about, but then when you're stuck dealing with it for a deceased loved one, like the utility company, do you know their account number? What about the water and trash removal companies, right? So if you're inclined to do spreadsheets, it's great to have a list of all of the accounts that you regularly deal with that will need to be closed out. If you don't, just including the first page of each statement, you just want to leave a trail. There are other, and I'll mention one, but I'm sure there are many other options. There's a company called Knockbox. It's Nokbox. For about $150, you can get a box, and it has folders for all the different types of important documents that it would be helpful to have organized and waiting for somebody in the event of death. And it's helpful to do something like that. I know on Amazon, you can get the folders yourself, the Knockbox, and I don't have any relation to this company. It's just popping up on a lot of my feeds lately, and it seems really nifty. If you don't have an estate plan where your estate planning attorney has walked you through what to organize, this is kind of a quick and easy way to get things organized for your own family. Keys, right? Extra copies of keys. Do you have a storage shed? Do you have a garden shed out back with a lock on it? It's these little bitty things that families, when they're trying to process grief, now they can't find the key to the garage, and somebody's sitting in the floor crying and everybody else can't understand why. So, how long should you keep the estate open before filing the final tax return? That's going to depend on what the court says about because the court has to approve the distribution of the assets. So that is, and I'm glad people are asking questions about that, because I forgot to mention that. One of the things you need to do within the first 3 to 6 months is figure out the tax situation. If you are accustomed to using a CPA, then go to your CPA and have them walk you through that. If you are accustomed to doing things on TurboTax and you feel very good about it, then I'm sure they can walk you through it as well. I have always handled our family's tax myself because we don't have a complicated tax situation, but I made sure that I went to a CPA who commonly did estate tax returns when my father passed away, because that is enough different that it's often worth spending a little bit more to get somebody to help walk you through everything you need to do. And then somebody has asked, is it wise to put assets such as a house in a trust? There are 2 types of trusts. One is the probate avoidance trust, and that is a revocable or revocable trust. You can change it for the rest of your life. You are in complete control. And if you put a house in that trust, then you avoid probate. And for some people, that's really helpful. If you have minor children or a mortgage on the home, that can make things much smoother after a death. If you live in a state where the probate process is very unpleasant and costly, and earlier we talked about California and Florida being 2 states that I hear often having lengthy and financially burdensome probate processes, then it would be advantageous. In Kentucky, it almost always costs less to create a trust, a revocable probate avoidance trust, than it does to help an attorney assist you with probate. But the important difference is when you're paying for an attorney to help create a trust and to put your house in that trust, then that's money you could otherwise be spending on you while you're alive. Dealing with probate, the kids are taking money out of the estate or coming up with it themselves. So it's just a judgment call. Every adult needs good, robust powers of attorney in place so that we have trusted helpers who can help us while we're alive, but incapacitated, because the alternative is guardianship and nobody wants that. But our powers of attorney die when we die. Everybody who has children or wants to make sure that they have a customized set of instructions for who gets what and when after they're gone, they need wills. Nobody needs a trust, but a lot of people choose to do it for very good reasons. Now, there's another type of trust. It's irrevocable, and it's an asset protection trust. It's either protecting assets from estate taxation, or if you've not saved enough for your long-term care costs, it can help with Medicaid or VA benefits planning. Those, again, are not for everybody, because to get the protection, you have to give up control of your assets, right? So if you don't have trustworthy kids, that's probably not the best estate planning vehicle for you. If you're inheriting a house, should you go ahead and put your name on all of their utility and insurance bills associated with the house while the parent is alive? That is a personal decision. It can help make things a little bit smoother, but it does bring up an important point. A lot of folks, Google Esquire, who graduated bottom of his class from an unaccredited law school, has gotten the word out that to protect assets, you should just put them in the kids' names. That's very bad, no good thing, even in Australia, for you Judith Viorst book lovers, because two reasons. When you put an asset in somebody else's name, then when they die, it's governed by their estate plan, and it's subject to the claims of their creditors. For homes in particular, it's important to remember that when you give somebody an asset that can increase in value, you are giving them, for tax purposes, your original purchase price. So that then when the person you gave it to goes to sell it, they pay capital gain on the difference between the original purchase price and whatever they sell it for. Whereas if you inherit a property like that, what you inherit is a brand new valuation, which is the value it was on the date of the loved one's death. So for some communities where housing prices aren't fluctuating that much historically, maybe not such a big deal. Imagine somebody who bought a beachfront home in Carmel in the 60s and gave it to their kids. Their kids are now selling a multi-million-dollar asset that was purchased for what, maybe $75,000. Huge capital gain tax liability. Whereas if they had inherited it, then they would get they would pay only on the difference between the value when the loved one died and when they later sold it. So ignore Google Esquire about putting assets in children's names. Social Security not recognizing a POA. So you need to become a representative payee or fill out the government's form. There are times when we want to go toe-to-toe and enforce our rights, and sometimes we just take the path of least resistance. So the Social Security Administration does have their own form, and you need to just go ahead and fill that out. How do we put a home in a trust if there's a mortgage? If it is a probate avoidance trust and revocable, there is a federal act which says the mortgage companies cannot stop you from doing that by triggering their due on sale clauses in the mortgage. If you put it in a probate avoidance trust and you retain control, then the mortgage company can't have any say about it. You do want to let your insurance company know that you've done that, though, just so they're aware that the trust exists and is an interested party for the insurance. Now, with these asset protection trusts that seniors do for long-term care benefits planning, if there's a mortgage on the home, The federal act does not apply to these irrevocable asset protection trusts. I've had a lot of success for the Medicaid planning in convincing the mortgage companies that because of the way we do it, it is effectively the same thing as the act was intended to protect against. But there is no guarantee of that. So if your loved one needs to do Medicaid planning and they have a home with a significant mortgage on it, where they got the mortgage at 3% and now they're whatever, you really need to think carefully about the risks versus the rewards of doing that.
Larisa, there was a question back further. Does a car need to go through probate?
It depends. So if you have another name, an and or, then it doesn't. Depending on the value of the vehicle, it might be able, if that's the only thing out there, it might be subject to the small estate administration. But cars these days, in Kentucky, the threshold is 30,000, right? So if you have a Tesla and you've forgotten to put your spouse's name on it, that now requires full probate.
Okay.
Step up or down in basis. I'm not sure. Nicole, what was that? Okay, I'll pass over that. The other one says, my mother has a couple of insurance and investment accounts in her name. I'm a POA, but should those be put in a trust or specified with me as payable on death? So if she has a will, to avoid family conflict later, to avoid probate with investment accounts, you can have transfer on death designees. So then they don't have to fool with probate. But things can get a little bit dicey if, for administrative convenience, you have them all coming to one child, but the will says divide equally among 3 children. Now that one child gets it all, and then they've got to gift it to the other 2, or they don't have to honor the will if the parent did it themselves. I would be very cautious about using your POA powers, though, to do anything that appeared to be administratively convenient, but didn't line up exactly with the will or the trust provisions. So you can divide an investment account through transfer on death designations amongst more than one person. Just think carefully before you start doing that. If there's nobody named, then it goes to the estate and it will trigger probate. And then the court will supervise the division of who gets what and when. If there is a will, the court will insist that the terms of the will be followed. If there's not a will, the court will look to the state's off the rack rule for who inherits from somebody who didn't leave a set of instructions. And then back to Nicole for the house sale. What I was talking about, you're absolutely right, is basis. So if you give somebody an asset that can appreciate in value, you give them your original basis. If that person inherits from you, then they get what's known as a step up in basis, which means it doesn't matter what the original purchase price was. The new basis is the value of that asset on the date of your death. And then more information about small estate administration. Unfortunately, that's something that varies from state to state. Some states simply have a value, like anything less than 50,000 can go through this process. Other states like Kentucky, it's both a value and only certain relatives are allowed to use it. The surviving spouse, or if there is none, the surviving children. I can't tell you about all 50 states, but there is a link in the materials that will allow you to look up your state and see what is there. How do you recommend finding a good estate planning attorney? The best source is always, because estate planning is such a personal thing, ask your friends in your community whom they liked, whom they didn't. The one rule of thumb is this: you want to make sure that whomever is doing your documents, all they do is estate planning, right? You don't want to go to a title company. You don't want to go to somebody who does wills, fixes parking tickets, does real estate transactions, right? Every attorney with a law degree is permitted ethically and legally to write a will. Just like I am permitted to file a patent application, I would no more do that than I would sprout rings and fly, because I do not have the education and training to properly advise clients about that, right? But every attorney every little storefront attorney seems to think that he or she can toss out a will really quickly. Poorly written wills, although legally valid, can do more harm than good. So whomever you meet with, you want to make sure that all they do is estate planning. If you are in the area where you need elder law involvement, the best place, in my opinion, to start to look is the National Association of Elder Law Attorneys, and their website, naela.org, has a find a lawyer search feature. So you can start there. If you're younger, then just word of mouth.
That's great.
Um,
I see that. Where do I
Can
find
you
it?
explain why would you need an elder? What's the difference in getting an elder care lawyer or an
Sure,
estate planning
sure.
lawyer?
So there are some common threads amongst all estate planning, but the needs of my 21-year-old son, who does not yet own real property, are vastly different than the needs of my 88-year-old mother. So particularly as couples age and they have known conditions with their children, you want to have somebody who is knowledgeable about issues specific to the elderly population who might possibly lose capacity, or who might have children now with known conditions that we need to account for. So it's very important as we age, although I include these provisions in all of my wills, that there be some language in the plan that says, if anybody who inherits from me is receiving means-tested government benefits, like Medicaid, SSI, then their inheritance, my plan says that their inheritance will be held in a way that they can stay on those benefits, and what they receive from me will supplement them and not replace them. So that's one thing that you want to do. Also, with the powers of attorney, what the provisions that need to be in them for somebody who's 45, at the peak of their professional life, a business owner, they need to have special paragraphs in there that would give their trusted helpers powers to do things that are relevant for that stage of life. When we start moving into the elder law stage of life, we need provisions in there that would prevent any need for guardianship or conservatorship. You need the ability to deal with government agencies being more explicitly stated. You need the ability to do long-term care planning or Medicaid planning on behalf of the loved one to be more explicitly stated. And an elder law attorney is familiar with all of those. And you also need somebody who's, because elder law attorneys are thinking about possible risks, right? Powers of attorney give a lot of power to our trusted helpers. So an elder law attorney is familiar with looking for red flags in the family dynamic, drafting the powers of attorney in a way that will give loved ones the ability to help when they need help, but prevent an unscrupulous loved one from taking advantage. Is there any legislation pending that when a loved one has no assets but wants to stay in an assisted living facility, that the government would pay what they would to a Medicaid facility and a family member pay the difference in cost so the loved one could stay where they are? I'm not sure, I'm not aware of any, but that does bring up a good point. When your loved one goes into an assisted living facility, they will typically include language in the contract that tries to make you agree to be personally responsible for your loved one's debts. You do not have to agree to that. Simply by acting as the attorney in fact, you are figuratively standing in their shoes. So it's your loved one that is responsible for the cost of care, not you. They will make it seem as if you have to personally sign a guarantee. You do not. Is there a requirement to file an estate tax return for my late mother who had no assets required to be probated since they were owned jointly with my father? I would consult a CPA about that. I'm not allowed to give specific tax advice, but anytime that somebody dies, you want to get some competent help to talk you through filing your last joint married tax return. But if there's no probate estate, I can tell you, if there's no estate required to be probated and everything just passed by operation of law, I am fairly confident that your CPA would say that no, an estate tax return is probably not necessary. Yeah, so depending on the size of the estate, Nicole is right. It is helpful to have a team of people working with you. The financial advisors to make sure any estate planning documents are read properly and the distribution happens according to those set of instructions. A CPA to guide you through the filing of the final individual tax returns or an estate tax return. How much you want to invest in that process, of course, depends on the size of the estate. If you've only got $5,000 and you still have to go through probate, then I would recommend you just going down to the probate clerk's office. They're typically very, very nice and helpful. You know, people fight over money in civil court. There are criminal cases, but everybody, with rare exception, understands grief and the loss of a loved one. So the folks in the probate clerk's offices tend to be just lovely and helpful outside of California or Florida.
Larisa, there was a question Evelyn had about Social Security deposit. I don't know if you
Yes.
saw it in the chat.
Yeah, the best thing to do on that, although get yourself a good comfortable seat and a glass of tea, is to call the Social Security Administration just to confirm. I always recommend that you leave money in the account and not drain it, even though it's there for a couple of months, just to be sure. The ship of state moves forcefully, but slowly. So it's, these things don't happen as quickly as we would like. If there's any concern at all, I recommend calling your local Social Security office and asking for their comment. They will tell you over the phone.
What is that, Larisa? If somebody passes on the 15th, what's the cutoff for the money has to go back to Social Security or it stays in your account?
I'm not sure about the 15th because people's Social Security payments happen on different days of the month. Not
Right.
everybody's is the same,
Right.
but they do prorate.
Okay.
So if you payment hits and you die the next day, they're going to take a portion of that back.
Okay.
And if you die April 30th and your payment hits May 2nd for the month of May, they will take all of that back.
Okay. And that will happen automatically. It's not like you're going to get an email from Social Security as we continue to get these types of fraud type of interactions. No?
Yes, Social Security will not call you.
Mm-hmm.
The IRS will not call you. They will send information by mail.
Okay.
If my dad dies first and has the larger amount, does my mom get half of his Social Security and hers? So no. If they've, so I'm assuming they've been married for a while. The way it works is, when my father passed away, he historically had higher earnings. So I'm going to use round numbers. He was getting $3,000 and my mother got $2,000 based on her own earnings. So when he passed away, then she got a bump up. So now she's receiving $3,000. So they match the highest value of the married couple before. So you don't automatically get half of the higher wage earner, but you do get a bump up so that you're receiving at least as much as the higher wage earner. Did I miss any?
I don't think you did.
Okay.
I will bring up the, as you said, Google Esquire. There's plenty of information and there's plenty of accounts that like to talk about law on Instagram, on TikTok, on Facebook, and they all sound like they know what they're talking about. How do we
As do
distinguish?
brothers-in-law.
Yeah, as do brothers.
Brothers-in-law, unless they are estate planning attorneys,
Yep.
they don't know whereof they speak.
Yep. Okay.
That's a very good point. I'm glad you pointed that out. Yeah, I get a lot of people coming in. The Medicaid myth is that the government's going to take my house. No jackbooted thugs show up and demand the keys. The government does expect to be paid back if they have fronted the cost of your very expensive care, and there are ways to avoid that. But again, jackbooted thugs do not show up and demand that you leave your house. Similarly, for estate planning, the big myth that I alluded to earlier is, well, it's best to avoid probate by just putting everything in your kids' names. Well, again, if your kids die, then that asset is now controlled by their estate plan, and their spouse may be bitterly resentful of all the snide comments that you have made over the years at Thanksgiving and Christmas about their parenting, their hair color, you know, all of these things. So better to have a formal estate plan or beneficiary designations than transferring assets to your kids just to avoid probate. And then one other cautionary tale, even though I've been joking about some places where probate is miserable, don't let a fear of probate cause you to do foolish things. So if your loved one has a will, and you are their power of attorney with the ability to change beneficiary designations, don't let a fear of probate cause you in the end stages of their life to just go online and talk to the financial institutions and make sure that everything passes by beneficiary designation, because that subverts the will. And what if your loved one wanted to make specific gifts to charity or to friends, little bitty gifts? Well, now those don't happen. And the people who receive the money by beneficiary designation can choose to honor the wishes expressed in the will, but they certainly don't have to. So be aware that probate is sometimes something we want to avoid, but if you're managing affairs for your elderly loved one, don't use the power you have to willy-nilly subvert the intention of their will. If you subvert it away from family members with a legitimate claim, that's going to be a very big problem because they will allege you have abused your authority. But even if you don't use it to benefit yourself or against the will, you need to make sure that if they've made specific bequests, that those bequests are honored, even if that means you have to go through probate.
Oof.
Oh, some people don't want to hire a lawyer and just say use LegalZoom for the will. You can do that, I've had a lot of folks come in to have me review their legal Zoom documents. I have yet to see any that produced valid documents. And part of the problem is that you're asked to make a series of choices, and you don't know why you're being asked to make those choices or what the significance of them is. I have seen people go online using Dave Ramsey or Susie Orman forms, and just to save a little bit of money, and they create perfectly valid estate plans for a different state. Or they create trusts and don't put any assets in them, right? Because they don't tell you now you've got to fund your trust. And then they lose capacity and their loved ones are stuck with it. Or little things like they don't sign them properly. There are very specific rules for what has to happen when you sign these legal documents. And that doesn't happen either. And then there are little bitty things that an estate planning attorney would talk through with you and make sure you understood the significance of it. So you have a house. LegalZoom asks, all right, do you want to leave everything in equal shares to your kids? Yes. An estate planning attorney will say, that's fine for money, but let's think about that real property. If you leave everything in equal shares to your kids, then you've got 3 names on the deed now. There's typically one child who wants to cash out immediately because they need the money for their family, or that's how they process grief. They've got one child who can't bear to sell it because that was mom and daddy's house, right? And then usually the middle child is playing both ends against each other or just dragging their feet. So that leads to family discord and is easily avoided by working with a qualified estate planning attorney to walk you through ways to get around that. And that's just an example of the many issues, with an estate planning attorney can help you think about, well, how do we protect some of this money for the kids' eventual use, but make sure we do that in a tax efficient way that will give the survivor access to the money for as long as they want it. LegalZoom just says, who do you want to get it and when? So estate planning does not have to be expensive. It can be if you need to do a lot of complicated tax avoidance. But for most people, it's worth it to pay a little bit more to have the expertise to walk you through the choices you can make and explain the significance of all of them than to leave your family with a mess because you didn't know which choices were important and which were not. It's not an area in which we want to be penny wise and pound foolish.
What is that kind of range, Larisa, for an estate planning attorney?
Yeah, it depends on your area and it depends on the quality. So again, if you go to a title company or somebody who does a bunch of other things, they might offer to do it for a couple of $100s and you're not going to get very good quality. In Kentucky, the range for, I'm happy to tell you just sort of generally what I do. I do flat fee billing and they get a package of documents. And the reason I do flat fee billing is it's important that my clients ask me questions, think about things, and take the time to process what I'm telling them. If I were billing them by the hour, they probably wouldn't ask as many good questions. They probably wouldn't be willing to take the time to learn what's in their plan and go from there. So for me, for young adults and a starter package, that's typically between $600 and $900, depending on what they need, which includes a will, very good powers of attorney, and healthcare powers of attorney. My average revocable trust-based plans for single people, they're a little bit lower, and they range from $2,000 to $3,000, depending on how much complexity. And then for married, it goes up a little bit. But unless you've got complicated tax issues, it really should be under $5,000 for most people. Now, I will caution you that these asset protection plans, the Medicaid asset protection plans, they are more complex. They require a lot of education, a lot of very specialized drafting. So for those, for the long-term care and the VA benefits planning, those are typically a few $1,000s more So just expect that if you're helping an elderly loved one, do that. But even in that situation, the attorney should be willing to meet with you at length and explain the realities of Medicaid planning, what Medicaid looks like when you're on it, and the realities of administering these trusts for a loved one. If they are not willing to do that, and if they fob you off on a paralegal, then you might consider continuing to interview elder law attorneys until somebody explains to you the intricacies of that asset protection plan that you're helping your loved one create.
Okay. That's great. And when you're trying to find one, what's the best? Are there any questions that you could share that would make, that would weed out the, boy, they don't know what they're talking about, or boy, this one really understands?
Right. Ask them if they've ever had to deal with something for a loved one of their own. Ask them how long they've been practicing elder law. And this is elder law specific. There is a certification, a certified elder law attorney. It's called CELA. So if the attorney you're interviewing has that designation, you can be fairly confident that they know what they're doing. That requires a minimum number of years experience and some pretty rigorous testing. So that's a good shortcut. The other thing you want to make sure of is that you just get a good feel from them. Are they willing to talk to you? Are they willing to answer your questions? Or do they start getting antsy?
Mm-hmm.
You should have somebody who's empathetic and is willing to walk you through it. I can spot an estate plan prepared by somebody who's never lost a loved one a mile away.
Really?
A mile away. Yeah. And then in our firm, we all have our own individual strengths. I have a colleague who grew up in blended families, and we always turn to him for guidance about what are some issues that blended families face after a loved one has died, that those of us who grew up with parents who stayed married to each other for our lives, what do we need to be thinking about? What tends to upset the kids? What tends to upset the surviving spouses? How do we draft a plan that's likely to make sure everybody gets at least as well as they were before the first person died?
That's great. Okay.
If you're a farm owner or a business owner, you want to make sure that your estate planning attorney understands how that affects the estate planning.
Ooh, that's a lot.
That's a lot.
That's a lot. Yeah. Wow. I think we missed one from Evelyn. If the parent who passed had a lower amount of Social Security, then the survivor only keeps their own amount, correct?
That's correct.
Okay. Yeah.
You get to keep the higher of the two.
Yeah. Okay. Whew.
Question, Larisa, will an attorney let you interview at no charge? Like, can you interview them and ask them some of these questions without them charging you?
Typically, different attorneys do it different ways. So it's not uncommon for some firms, your first interview is by phone with an intake specialist, and then a paralegal will meet with you, and then the attorney meets with you for the legal questions. Our firm does not do things that way, but that's just a matter of choice. And the reason we don't do things that way is we've experienced dealing with loved ones in crisis planning and family members who didn't want to plan, and now they're finally willing to do it. And when you've got someone who's been reluctant for many years and now they're saying, okay, if they've got to talk to somebody on the phone and then they've got to meet with a paralegal and then they've got to watch a video or go to a seminar, I mean, you've lost a lot of ground there. So just because we all know what it's like to want to get something done quickly, you meet directly with the attorney at the beginning. So that's not, one system is not better or worse. It's just what works for your family. No attorney is allowed to give you fact-specific advice without an attorney-client relationship. So that's why I can't answer specific questions about your personal family tonight. But an attorney at a minimum, or the firm at a minimum, should be willing to talk through with you about what your concerns are, what you're worried about, what your family situation is like, and how they might be able to help you address some of those concerns. Any other questions?
I just put your
Oh, okay.
law firm in of Gilbert, Weinreich, and Watkins. Larisa, I mean, the information that you have, I thank you. I mean,
Oh,
really,
you're
thank you.
welcome. I'm always happy to help. Happy to help.
We
And I'm
will-
happy to stay on the line, but if nobody has more questions, the Gilbert child most likely to pick my nursing home just ran in a track meet.
Okay.
And I want to go make sure I congratulate her.
No, that's fine. I will be sharing, I'll share my screen real quick so everybody can just see this. I will be sharing this with everyone.
wonderful.
I'll send that right out tonight.
That's the checklist I was talking about. That's
Yep.
the one that's helpful with general information. But again, if you've got a loved one who is annoying the stuffing out of you and just needs a job, hand them the checklist.
Lots of stuff. And there's even a letter down here. Well, after all the explanation, but it's a pretty comprehensive document. And then here's a letter for the Equifax, for usage, which is great. Like I said, I will send that out tonight. I will also send out the recording of this once we get it, done, taken care of and uploaded and all of that. I do see Maddie has her hand up. If you can take one question there.
Sure.
Maddie?
Yeah, yes, thank you. Hi. I
Hi.
was wondering if you could speak a little bit about estate settlement, and is an attorney necessary for that?
Sure. It depends on the estate, how much is involved, and whether you have to go through the more lengthy court supervised process or whether you can go through the small estate administration process. If it's a small estate, and the rules for that vary state to state, and there's a link in the materials that will allow you to look up the rules for your state, then typically you don't need an attorney. It's designed to be streamlined and easy. Now, I will tell you that even though people don't need an attorney for that typically, I still get a lot of calls from folks just wanting me to handle it. And the reason is grief, plain and simple. It's not difficult. They don't really need me, but I want one task off their hands so they can just deal with grieving. So at our firm, we don't charge very much for that at all because we recognize that the person's grieving. It's not going to take a huge amount of our time, and we can get it done for them quickly and easily, and then they can just go about their business. For a larger or more complicated estate, particularly if there's not a will that you can find, it's often helpful to have an attorney assist you with the process. The attorney can run interference with other family members. They can tell you what you need to do, what you are allowed to do, and they can guide you through the process from beginning to end.
Okay. So is it necessary for an attorney to get tax ID numbers, new tax ID numbers for trusts that were in the name of the the parent who passed?
If it was just in the name of the person who passed, and if they'd been able to use the parent's social security number before, then you will need, by the terms of the trust, if it was just for one person, it will become irrevocable and you will need to get a new trust ID. If there's no trust, but there are estate assets, somebody, once they are appointed executor, personal representative, or administrator, and the attorney can do this for you once you're appointed, will need to get an estate tax ID in order to open up an account to hold the estate financial assets until the court supervised distribution of those assets can take place. But you can do that yourself. You don't need to pay an attorney to do it.
So for example, my parent just passed away. I could apply for an estate tax ID.
Have you been appointed the executor yet?
My mother's will and trust appoint me as executor.
Have you started the probe? Do you have a court doc? Well, let me back up. Are there any assets that don't pass? Are they by operation? Are they any assets outside of the trust?
No,
Are there any assets that were just in your mother's name alone without either a beneficiary designation or a transfer on death designation?
no,
Then based on what you've told me, there aren't any estate assets. There's just trust assets and assets that pass to you by operation of law. Does that sound right to you?
yes.
Yeah. So for you, I would recommend, instead of talking with an attorney first, that you talk with a CPA first and have them walk you through the tax ID issues for the trust.
Okay,
Yeah.
thank you.
Oh, you're welcome. You're welcome.
Larisa, one more.
Sure.
If my mom only owns a 2013 car and has no other property and has designated all to her brother and herself, do I need an attorney for the car only? And will I have to probate just for the car?
It depends on your state's rules. So in Kentucky, if that car were valued at less than 30,000, and if your brother was willing to sign the paperwork, you would qualify for the small estate administration. So you could get the paperwork you needed to retitle the car fairly quickly. I'm not sure where you live or what your local state's rules are, but it's likely, although I can't tell you for sure, that you would have the option of doing the small estate administration. Now, the caveat to that is there's also what I refer to colloquially as the small town rules, right? So in small towns where everybody knows everybody else's business, sometimes things get done even though they're not done precisely the way the court or the law would require, but just because everybody knows your family, right? So if you're living in a small rural town and everybody knows everybody else in the county, it's possible the county clerk will just retitle that vehicle if you and your brother are in there. That's probably not in strict accordance with the law, but sometimes efficiency trumps strict accordance. In Louisville, that won't happen. You have to have the official papers before they will retitle any vehicle for you.
All right. Larisa, you're the bomb. Thank you.
Oh, well,
Really,
thank you.
really well done, concise. I mean, I think you covered everything, and appreciate you taking the time out of your day and at the end of your
Oh.
day, I believe.
Happy to do it. Although this fluorescent lighting makes me look like Nosferatu here. I didn't realize that till I looked at the screen.
Not at all. Not at all. You look great. You look great. I will get all this information out to everyone. As always, information for upcoming circles is at daughterhood.org. Larisa, I have a feeling people are going to want to hear from you again. So,
Happy
you
to.
know,
Always.
okay. And lucky for everyone as well, Larisa was a guest on the podcast with me, and we covered lots of information there as well. So,
Yes.
can always seek that out. I will send links in the email, but I will get everything out to everyone this evening, and I'll let you know when the video is ready to go as well. So,
Well, thank you all for taking time out of your evening.
thank you.
Thank
Thank
you.
you. Thank you,
Thank you.
everyone.
Take care.